And a very good morning to you. This is John Fradgley from the Bell Legal Group, back with you for another program of The Law and You. And in fact, our second last program for the year. So if you're needing some legal advice before that fast approaching Christmas, you need to ring either today or next week. The 17th of December will be our last program for the year. If you need to get through to us, of course, our telephone number 55208888. That number again, 55208888. Don't forget, you can send us questions by email to talkback@4crb.com. But we do need to receive those questions before the start of the program each week. So, if you do email now, we will deal with that next week. But you can email at any time between now and next Monday, and we can deal with that on our last program for the year, which of course, as I said, will be next Tuesday. Don't forget, if you're south of the Tweed River, you need to put 07 in front of the number to call us. Otherwise, throughout the rest of Tweed Heads and Queensland, you'll get straight through on 55208888. And thank you to all the people who rang in last week. Certainly a very interesting program, that's for sure. And so I thank you for those calls. You may remember that John rang about online defamation, and in particular, whether a publicly listed company can sue for defamation. Now, when the Uniform Defamation Laws came in Queensland, I think back in 2005, publicly listed companies are no longer able to sue for defamation. But this doesn't apply to not-for-profits, which are quite often public companies limited by guarantee, nor does it apply to small businesses, even where they are incorporated, where they have 10 or fewer employees. So just basically in a nutshell, that's the rule. However, I did make mention of something that I referred to last week as criminal defamation. What I had in the back of my mind, and I since clarified this week, was that even a publicly listed company can sue for injurious falsehood, where there has been malicious publication of false material that causes special damage to the corporation. Now, it's much harder to prove than straight-out defamation, but nonetheless, I think the lesson or that we should all take from this is that we need to be extremely careful with what we publish, whether it's online or in the press or a letter to the editor or anything of that nature. You need to be extremely careful. And I've always taken the view that if you're annoyed about something and you want to write a letter about it, that the best idea is to write the letter as a draft, put it in your bottom drawer and leave it there for a day or two, pull it out and reread it before you do anything with it. And ideally, if you have someone else who's a fairly level-headed sort of person who takes an objective view to things, it can sometimes be a good idea to get them to read over whatever it is that you have a bee in your bonnet about before you actually publish it, so that you don't end up running foul of the law. Because don't forget, you can defame people. So don't misunderstand what I'm saying today. This only applies to the defamation of publicly listed companies or corporations which have more than 10 employees. So, and certainly doesn't apply to not-for-profits, and as I say, those small corporations either. But enough of that. We've got Brian on the line, as we say. Good morning. Hi, Brian. How are you today?
Good morning, John. Good, thank you very much.
How can we help?
The question I would like to ask is, when you do a will, which is more than a couple of pages long, do you have to have witness signatures on every page as well as your own? Or can it just be on the last page?
Look, it can be on the last page, but ideally it should be on every page. And that particularly applies where the will paper is not joined. So in the old days, talking back in the 70s, we used to have will paper that was actually a double sheet. So you could type four pages or 3 pages onto one sheet of paper, and because that piece of paper wasn't cut, therefore you could sign it at the foot or the end. But where the paper is cut, or where it is, particularly if it's joined together with a staple, it's most advisable for the testator and the witnesses to sign at the foot of each page. And for the pages to be numbered so that it is quite clear that it goes, say, for example, from page 1 to 10. And the other thing, of course, is that ideally it should also be signed with the same pen, so that the testator and the witnesses all sign with the same pen. Now, if a will is bound together, so in other words, it's been bound after it's been signed, and it's been the binding has been done in a way that the will cannot be pulled apart, then it's probably okay to only sign on the last page. But my preference is always to make sure that it's signed on every page. Every page.
Great. That answers my question. Thank you very much for that, John.
Okay then, Brian, all the very best.
All the best. Same to yourself. Bye for now.
Bye now. And the time on 4CRB continues to march along as we say a very good morning to Stan. G'day, Stan. How are you today?
Good morning, John. I'm well, thanks.
That's good. How can we help?
The power of attorney form that you can download yourself, does that stand up legally?
I'm not sure what form you're talking about. So, are you talking about a Queensland power of attorney form or New South Wales?
Queensland.
Queensland form. Okay. Well, as long as it's the form that is issued by the Queensland government in accordance with the provisions of the Powers of Attorney Act, I think from memory it's 1998, then it would be okay. So, and the short form power of attorney, I think from memory goes for about 12 pages or maybe a little bit less, maybe about 10 pages. And then you've got the long form power of attorney, which goes for about 15 pages or so. The difference between the two is that the short form power of attorney is the one that you use when you're appointing the same person to be your personal attorney and also your financial attorney. And the long form is the one where you want to have different persons fulfilling those roles. So if you want particular family members to look after your personal affairs, but you want your accountant to look after your financial affairs, then you would use the long form power of attorney.
Okay. The power of attorney form I have seen only allows you to put in 3 powers of attorney. What if you want to elect 4?
Well, yes. You certainly can have 4 people appointed as attorneys. It sounds to me like that you're talking about the last page where the attorneys have to sign their acceptance.
No, when you nominate their names.
Right. Look, I must confess I've not used that form because we prepare these ourselves within our office, and certainly there is no restriction in putting in more than one. In fact, I was just reviewing a power of attorney last night that had 4 attorneys in it. It does make it a little bit difficult when the form only does allow space for 3. I don't know how you would get around that other than by perhaps getting one prepared by a lawyer.
I see. Okay. Oh, that's fine. Thank you. Thanks for that info, John.
Yes. All right. Well, all the very best with that, Stan.
Thank you.
And
Bye-bye.
The time on 4CRB is just coming up to 14 minutes past 9. The Law and You is the program, 55208888, the number. Don't forget, this is only the second last program for the year, so if you have a question or a query that's really on your mind and you need to get out of the road before Christmas and you want to have Christmas in peace, you need to give us a call right now, 55208888. No calls on the line at present. We'll be back after this word from our sponsor.
If you're retired or coming up to retirement, you should speak with Independent Wealth Management. Founder Tony Walker and the team, including David Bird, Linda Griffith and Joe Walsh, have an average of 30 years experience each, helping clients meet their financial planning objectives in retirement. Independent Wealth Management is a privately owned family business, not owned by a big bank or insurance company. IWM is an FPA professional practice. Phone 56363800. Australian Financial Services Licence 493459. A sponsor.
Harvey Norman South Tweed deliver anywhere and they guarantee to beat any genuine competitor's price. And if you want good old-fashioned service, then Harvey Norman South Tweed is the place to shop. Their specialised staff will give you the best advice for your needs. With a great range of computers, furniture, bedding and electrical, there is no need for you to shop anywhere else. Why don't you go and see the friendly staff at Harvey Norman South Tweed? Because customer service is their priority.
Another sponsor.
So my highly efficient panel operator has just downloaded the form of power of attorney, and I was wrong in my estimation of how long the form is. It actually, even the short form appears to go for 20 pages. So that's what happens when the government simplify things. Back in the old days, enduring power of attorney was 1.5 or 2 pages. But yes, you're quite right, Stan. The form on the website only allows for a third attorney. So in that situation, what you might have to do is to put another place in for a fourth attorney to sign, if you wanted to use that particular form. And of course, don't forget that back in the actual appointment part of the form, you'd need to have enough room to put that other name in as well. So there we go. All right, but enough of that. We've got Brian online. Hello, Brian. How are you today?
Very well, thanks, John.
That's
John,
good.
I have a will that's drawn up by a lawyer. He's the executor, has power of attorney.
Mm-hmm.
I wish to make some changes, not minor, just in regard to beneficiaries.
Mm-hmm.
Is that I have to have a new will drawn up, or
No.
can...
Sorry, it's one of those classic, sorry to cut you off there, Brian. It's one of those classic questions that lawyers love to answer with the response, it depends.
Okay.
So it depends on the changes you're making. If you're, for example, if you had someone in the will and you were leaving them, a bequest, and then you want to make a change where you're going to cut them out, then I sometimes think it may be better to do a new will, because if anyone who's named as a beneficiary in a will is entitled to see a copy of the will, and that includes where they're named as a beneficiary in a previous will. So if you were worried about offending someone, or that they might be offended after you're gone, it's not going to worry you too much then, but nonetheless you may not want the person to have hurt feelings. It's probably better to do a new will, because that way their name wouldn't appear. But if the changes aren't something that's likely to, where you're concerned it may offend someone, and for example you're wanting to add an executor, or you're wanting to add another bequest for another relative who's come back into your life and want to leave them a bit of money, something like that, those sorts of changes, certainly they can be dealt with through a codicil without any worries at all.
Right. Well, really, that's the one that I'm doing. I'm not cutting anybody out. I'm going to add somebody. So
yeah, all right. No, doing that, yes, quite straightforward. And normally the cost of doing a codicil, you're probably looking at around about $150.
Okay.
Yep.
Thanks, John.
All right, then.
Goodbye.
And this is the Law and You on 4CRB. Our telephone number 55208888. That telephone number 55208888. Lines are presently clear, so if you have a question or a query, get on the telephone straight away. We prefer if you can call now, because often, as in last week, we have a bank up of calls coming in for the last part of the program, and unfortunately sometimes I have to take some of those calls off air, which I would really prefer to take on air. Just a few things with the lead up to Christmas coming that might be relevant. Don't forget, of course, the provisions of the Australian consumer law in relation to the implied warranties in relation to goods. So if you're given something for Christmas, or you give something to someone and it's it's faulty or defective and the retailer is trying to give you a bit of a hard time in relation to getting your money back or replacing it, because in the first instance they can replace it. It does depend on also, of course, the refund policy that the particular shop has. Some larger department stores, etc., of course, have a no questions asked refund or exchange policy, whereas smaller stores will tend to only give a refund if the goods are not fit for the purpose, or alternatively they may have an exchange program. But it's always wise to take a look at the docket in relation to that. I myself fell into that category just the other day. I bought some goods from a store, and the fellow assured me that they were the correct ones that I needed for my vehicle, and it later transpired that they weren't. It didn't fit, and so I read their docket and noticed that it said that for refunds or exchanges that you were required to return the goods within 14 days. And so I did that. I was a day or two inside the 14 days, and the shop very willingly exchanged, and in fact was then able to give me the correct item that I needed, and acknowledged that in fact what I'd been told by the fellow previously had not been correct, and apologised for it. So just read those the dockets at the time, or quite often they'll have a refund and exchange policy up in the store. Also, don't forget that the ACCC is becoming far more aggressive in taking action against retailers and other businesses where they've breached the law. So I think the law is slowly but surely moving where it should have always been, and that is in favour of the consumer. Obviously, as long as the consumer is acting reasonably. But enough of that. We've got Heidi online. Good morning, Heidi. How are you today?
Not too bad, thank you. How are you?
Very well, thanks. How can we help?
I just have a question. A family member passed away last week, just recently, and I was going through paperwork to see what needs to be done. And while they had a will, but there was no assets to be left. The person's got, say, $500 in the bank, and that's all.
Right.
Do you still have to register a probate?
No, you don't. And in fact, you very well may not need to do anything with that money. What is going to happen in relation to the funeral?
The will actually said that the person wanted to be cremated, and that's already been done. And
but who paid for it?
I did myself.
Right.
That's
okay.
Fine. I'm not looking for any money.
Well, you should be able though to get the $500 out of the person's bank account.
Yes.
The bank, if you produce a copy of the funeral account and the receipt to the person's bank, they should make a cheque out to you for that amount of money, for the amount that's in the account, because presumably the $500 would be less than what the actual cost of the funeral was or the cremation was.
Yes, I've actually got my own card for the account, so I had access to the account.
Oh, okay.
It was my mother.
Right, okay.
But I didn't want to sort of do anything unless I sort of knew what I was legally sort of allowed to do.
Yes, well, as I say, if you paid for the funeral, you're entitled to be reimbursed. If there was insufficient money in the person's bank account to pay the full cost of reimbursement, then you're entitled to such assets as are available to partially reimburse you. All right, then. But
because she's got no assets, other than clothes and a little bit of jewellery.
Yep.
You don't have to file a probate.
No. Probate's only required where a person's got more than, in rough terms, more than $50,000 in a bank account. They hold shares in a public company, or they were living in a nursing home where they'd paid a residential accommodation deposit. So outside of those circumstances, no, you definitely don't need probate. All right, then.
Thank you very much for your help.
Okay, Heidi, all the very best. Time on 4CRB, 24 and a half minutes past 10 on the Tweed, and we say hello to Russell. G'day, Russell. How are you?
Oh, good. Thank you. Yes, I'm fine. I've got an inquiry about a will, and I'm the executor of an estate which includes assets over in Scotland, and I'm just wondering. I'm leaning towards needing to go over there. There's a unit over there, and I was just wondering what are reasonable expenses? What would reasonable expenses include for that trip?
Right. Okay. Well, first of all, you have to make a decision as to whether it's necessary to do that or whether it can be dealt with from here. If there are assets in Scotland, then you will probably the first thing you would need to do is get what are the assets in Australia? Do they require probate of the will?
Yeah, I've got the probate of the will.
Okay.
I've done all the taxes here. Everything's fine here.
Right. So you probably need to get a reseal of probate in Scotland. So that would be the first thing that you would need to consider. And the second thing you need to consider is whether in all the circumstances, the expenses are reasonable for you to travel over there to deal with the unit, or whether that can be done, over the internet or via email, etc., engaging a firm of lawyers in Scotland to deal with that issue for you.
Well, it's been quite a rigmarole because I've tried to get solicitors over there, and I was being quoted £3,500 just to organise confirmation of probate. Now, he only has a couple of accounts over there, some premium bonds and a unit worth £50,000. It's an old council unit, and I thought, well, they're asking quite a lot of money just for a confirmation of probate, which only cost £161. So I thought about going over there, but then I found someone that will do it for £850.
Right.
And but they're not. They've had it for a few months and done nothing. And
right.
So I can't get any information out of them, and I'm worried about how things are going over there.
Right. Okay. All right. Well, look, if in all, who are the beneficiaries under the estate?
Well, there's myself, and there's a niece and a nephew, my sister, and so forth. Well,
what I would suggest you do is discuss with them that you believe it's reasonably necessary for you to go over because of the problems you're experiencing. I would get together some estimates on cost, etc., for you to do that, because bear in mind you'll probably still have to engage lawyers over there, even when you do that. If you're not having any luck with the lawyers there, the other thing that you can always do would be to contact the Law Society of Scotland. To get a referral to another firm, but if you discuss it with the beneficiaries and they're comfortable with you doing that, I mean, obviously you can certainly deal with things better when you're on the ground. There's no question about that. So
I would have been a lot further through the
yes.
I would have gone over.
Yep. So discuss it with them. If they're in favour of you doing it and they approve a reasonable budget to do it, well, by all means, go ahead.
All right, I've got to get their approval.
Well, you don't have to get their approval because you're the executor, and so you have the right to make the decision. But you have to be satisfied that, in all the circumstances, that is the most efficient way to deal with it. And I just think, particularly if it's family, the last thing you want to have happen is down the track that everyone says, "Oh, look, you just went on a junket." We don't think it's reasonable. We should pay these expenses, and then you end up with, bad blood, at worst bad blood in the family, or at best bad blood, and at worst, someone taking aim at you for abusing your position as executor.
Yeah, well, that's what, like if I hired a car over there to get around places, would that be a reasonable expense?
If that's needed, then yes, it would be a reasonable expense. I mean, obviously the airfares would be a reasonable expense. Accommodation would be a reasonable expense. If you need a vehicle to get around, if the assets are in different places, then yes, that would be a reasonable expense. So you've just got to weigh all that up and make a decision from there. But unfortunately, we'll have to leave it there, Russell. We're just pressing up to the news. All the very best with that. Well, thank you to all the people who've called in today to make for such an interesting program. Don't forget, last program next Tuesday, the 17th of December, so put that in your diary if you're needing advice before Christmas. I'm John Fradgley from the Bell Legal Group. It's been great to be with you this morning. I'll look forward to being back with you next Tuesday. But until then, as always, it's goodbye and God bless.